Before we talk about probate, the legal process, the paperwork, the deadlines, I want to acknowledge something first. If you're listening to this because you've recently lost someone, I'm so sorry. Grief doesn't follow a schedule. It doesn't care about filing deadlines or property valuations or any of the things that suddenly need attention when someone you love is gone. Those things are real. They have to be addressed, but most of them are not as urgent as they feel in the first weeks. And none of them have to be figured out alone. That's why we're here.
I have sat with clients in the earliest days of loss who were handed a stack of legal paperwork and told to make decisions about property their family had held for 30 years. The system doesn't pause for grief, but most of those decisions, they can wait a little longer than people think.
Understanding the process is the first thing that makes it manageable. So that's where we start. Welcome back. I am Natalie Francine.
And I'm Alexis Nassif. Today we make probate understandable.
Can we start with the word? Because I think probate is one of those words that makes people's eyes glaze over immediately.
Yeah.
It sounds like something that happens to other people, something complicated and extremely distant.
Until it happens to you, and then it is very immediate.
When did you first encounter it, Alexis, personally, not professionally?
My first year in the business, a client's mother passed. Beautiful home, no will, 4 adult children who all had very different opinions about what should happen next. I watched a solvable situation become a 2-year war. That was 1980. I have never forgotten it, never.
And in the 45 years since?
The same story in 100 different forms. The details change, the pattern doesn't.
Yeah,
All
the
the same.
pattern is what this episode is all about. Understanding it so you can interrupt it for yourself, for your family, before it starts.
Yeah.
Plain language, Alexis. What is probate?
The legal process by which a deceased person's estate is administered. A court oversees 3 things: validating the will, if there is one, inventorying and value the assets and distributing them to the heirs after debts and taxes are paid. When real estate is involved, probate determines who inherits it, what's owed against it, and under what conditions it can be sold or transferred. It's difficult.
And every state does this differently.
It does. Significantly different. California probate is not Texas probate. The broad strokes are similar. The details, the timelines, the costs, the court requirements vary enormously, which is why a probate attorney licensed in a relevant state is not optional. It is the first call you make.
And do you know how long it takes, Alexis?
Simple probate, valid will, no disputes, no complications can be done in 6 months in some states. Complex probate, contested will, unclear title, multiple properties, family conflict can take years. The national average is somewhere between 9 months and 2 years. Can you believe that? 2 years.
It's a long time. And during all that time, the property just sits there?
It sits there accruing costs, mortgage, payments, property taxes, insurance, maintenance, all coming out of the estate every single month, while nothing can be sold without court approval. Yeah.
So the estate is essentially bleeding
Oh, yeah.
while the process unfolds.
That is exactly the right word for it, bleeding.
I want to put a real number on this because I think it makes it more concrete. In California, one of the most expensive states for probate, attorney fees on a $2 million estate can exceed $40,000 in statutory fees alone. Add court costs, executor fees, appraisal fees, you're looking at $50,000 to $100,000 and 18 months before anyone inherits anything.
For an estate that could have been administered in weeks with the right structure in place, it wasn't.
We'll get to that structure. First, with a will versus without, because a lot of people assume having a will means avoiding all of this.
With a will, the court validates it, appoints the executor named in it, and the estate is administered according to the instructions. It is still a process, but it has direction.
And without a will, Alexis?
The state decides who inherits. Intestate laws. Spouse first, then children, then parents, then siblings. The state's assumptions about what you wanted, which may have been nothing to do with what you actually wanted.
I want to linger on that for just a second because I think people assume their wishes are obvious. Of course, everything goes to my children. Of course, my partner is taken care of. But if that isn't documented legally, properly, the state doesn't know that. And the state doesn't ask.
I have seen estates go to heirs the deceased would never have chosen because there was nothing in writing to say otherwise. You know, it's got to be in writing.
Write the will, please. If you take nothing else from this episode, write the will. It is not morbid. It is the kindest thing you can do for the people you love. Now, trusts, because this is where the picture changes completely.
A properly funded trust bypasses probate entirely. When the trust creator dies, the successor trustee steps in immediately. No court, no delays, no public record, no $50,000 process. Private, fast, clean.
And the cost of setting one up, Alexis?
$1,500 to about $4,000 in most states for a basic revocable living trust. Sometimes more, though. Depends how complicated it is.
So we are comparing $1,500 to $4,000 versus $50,000 and 18 months. That math is not close and does not add up.
No, it is not close at all.
And yet the majority of people with significant real estate do not have a trust. Not because they decided against it, because they haven't gotten around to it.
Oh, yeah.
This is the most expensive procrastination in personal finance.
I will not put that on a sign, though. I would put it on a sign. I mean, who knows? It's not good. Got to put it down in writing. Make that trust.
Let's talk about when it goes wrong.
Which is all the time.
Because a straightforward probate, sad, expensive, but manageable, is not the worst version of this. The contested estate is the worst version.
Contested estates happen when someone disputes the will, the validations, the executor's decisions, or who should inherit what. And real estate is almost always the flashpoint. It is.
Because it's the most valuable asset and the most emotionally loaded one. The house where everyone grew up.
Yep.
The vacation property where 30 years of summers happened. You cannot split a house down the middle. You have to make a decision. And families in grief with different financial situations and different memories of those same rooms often cannot make that decision together.
The dispute is almost never really about the property.
Say more. Tell us more about that, Lex.
I'm happy to. The property is where the older grievances land. Who was the favorite child? Who sacrificed more? Who was excluded from the parents' lives? The real estate becomes the arena for a fight that has been waiting to happen for decades. That's very true.
I want to tell you what that cost, because I think the abstract is less powerful than the specific. 3 siblings. Parents left an estate with 2 properties. The family home worth about $1.1 million and the lake house worth about $600,000. Will divided everything equally. No trust, no instructions about what to do if the siblings disagreed. One wanted to sell everything immediately. One wanted to keep the lake house and buy out the others. One, who had been the primary caregiver for years, felt she deserved a preferential share and was not willing to negotiate on equal terms. The legal dispute ran 2.5 years.
What did it cost them?
Well, the lake house dock wasn't maintained during the dispute because nobody could agree. Nobody could agree to authorize the spending. By the time it resolved, the dock needed full replacement, $90,000 out of the estate. Legal fees for 3 parties over 2.5 years, over $90,000. The caregiving sibling received exactly equal distribution and left the proceeding not speaking to her siblings. They lost the money, they lost the lake house they all loved, and they lost each other.
For an estate that could have been resolved in 90 days. Can you imagine that?
If the parents had done the one thing differently.
Had the conversation with them.
That conversation changes everything. While they were alive, while everyone who needed to be there was still there. That conversation, what we have, what we want to happen, why, is the document that makes every other document work. The trust is the legal protection. The conversation is what makes the legal protection mean something to the people who have to live with it.
Boy, is that the truest thing anybody ever said.
For anyone listening who is navigating an inherited property right now, here are the 5 things to do in order.
1, find the deed. Know how title is held before anything else. This tells you whether probate is required, who has authority to act, and whether there are co-owners whose cooperation you'll need. That's one thing.
2, secure the property, insurance, maintenance, utilities. The estate is responsible from the moment of death. If something happens to the property while it's uninsured, a pipe, a break-in, a storm, that cost comes out of the estate. Don't let a preventable problem become an expensive one.
3, don't make any major decisions for at least 30 days minimum, unless there is a genuine emergency. Not an emotional one, a genuine one. Give yourself the month. Grief is not a good state for financial decision making. The property is not going anywhere.
I give clients this as explicit permission because the pressure to decide immediately is enormous and almost always manufactured. The attorney wants to move. The co-heirs want certainty. The real estate agent wants a listing. Everyone has a reason for urgency. Most of it is not real urgency. You have at least 30 days. Use them.
4, assemble the right team. Probate attorney licensed in the state, a real estate professional who has worked in probate specifically, not just a generalist, an independent financial advisor if the estate includes investment accounts.
The word independent matters so much here, enormously. We talked about it in episode 3. The professional who is working specifically for your outcome, not the fastest transaction. In probate context, that independence is not a nicety. It is protection.
5, get an independent appraisal, not a neighbor's opinion, not Zillow, a formal appraiser from a licensed appraiser. This is a foundation of every decision that follows. It does.
And if you are one of multiple heirs, get your own appraisal, not the one the executor commissioned, your own. In a contested situation, the difference between 2 appraisals can be the difference between a fair outcome and an unfair one.
Yep. That's all I can say. You're absolutely right.
For the listeners who are not currently in a probate situation, what does protection look like starting today?
3 things. A revocable living trust, funded properly, meaning the property is actually retitled into the trust, not just mentioned in a document. Beneficiary designations reviewed and current. And the family conversation must be had, and you get an attorney immediately.
On the trust funding piece, this trips people up constantly. They pay for the trust, they feel like the job is done, and they never actually retitled the property into it. The trust exists on paper. The property is still in their name. When they die, probate. The trust only protects what's inside. Get the property inside the trust.
And review it every time your life changes significantly. Marriage, divorce, new property, new child. The legal structure should reflect your life as it is now, not as it was when you set it up 10 years ago. I have to do the same thing now.
How often do you see people with outdated estate documents?
I'm one of them, constantly. I have seen estates where the beneficiaries named were people the deceased had been estranged from for 20 years. Can you believe that? People had passed away themselves. An ex-spouse from a first marriage who nobody had thought to remove. Update the documents. It takes one phone call to your attorney. Remember, call your attorney.
One phone call versus a family war. The math on that one is also not close.
No.
3 things before episode 8. 1, find the deed on any property you own or stand to inherit. Know how the title is held. This is the single piece of information that determines everything else in a legal proceeding. 5 minutes. Pull it.
Yeah.
2, if you own real estate and you don't have a trust, call an estate planning and attorney this week and ask one question. What would a basic revocable living trust cost for my situation? Just the number. That's all. One call. 3, if your parents own real estate and you've never had the conversation about what they want to happen with it, put it on the calendar, not as a formal estate planning meeting, as a conversation. I've been listening to the show and I realized I don't actually know what you want. Can we talk about it? That conversation is the most protective thing your family can do.
Yeah.
And it starts with you asking.
The lesson from today: probate is not something that happens to you. It is a process you can understand, prepare for, and protect yourself and your family within. Everything you need to do that you now have. That's right.
If you are in the middle of a probate proceeding right now, you have more options than it feels like from inside the process. You are not alone in it, and the decisions ahead of you are more manageable than the paperwork makes them appear. Come back to this episode. Share it with a sibling or a parent or a friend who needs it. That share might be the thing that prevents the war before it starts.
The conversation is the document that makes every other document work. Have it while you can before it's too late.
Next week, the great wealth transfer. $84 trillion already in motion.
Yep.
And your family's place in it. I am Natalie Francine.
And I'm Alexis Nassif.
This is Wealth, War, and Real Estate. Thank you.
Remember,
Go
we're
ahead.
not attorneys and we're not accountants. We recommend that you
Talk to your legal
counsel.
immediately. We are only providing a framework of what to look out for while you're going through this, or to prepare you if, when the time comes.
Yeah.
Because it will come.
It will come. I hate to say it.
And it's good to be prepared.
Yeah. And we said 30 days. In my opinion, I think it should be longer, that you don't do anything, because you have to clear your head from the grief.
Oh, yeah. But, and that takes years.
Yeah, that's true. It never goes.
No. Anyways, thank you.
Thanks. See you next week.
Bye-bye.